Good afternoon. I'm Avirup Bose and I teach. I'm the Assistant Professor of Competition Law and Policy at General Global Law School. And I think when I got this particular topic for today on competition law, I thought I jumped at it, and my paper is lack of India's regulatory imagination. And the idea of this paper comes from a larger project that I direct at General, which is where we are trying to do something in India which will mimic the wonderful work which the Competitive Enterprise Institute does in America, which they very cleverly title as 10,000 Commandments. We have titled it as the State of India's Economic Regulators. It is a periodic or an annual assessment of the behavior of India's chief or the biggest 5 financial regulators. But in a way, my discussion today is a lead on of where Professor Rajgopalan left. Is when she showed you those slides as to the lead in terms of India's socialistic background. What happened almost 24 years ago is that we tried to change it as far as our market or our economy is concerned. We opened up our economy and sort of liberalized to some extent, and a progressive ad hoc transformation of our economy began. A fundamental change happened in terms of our economic governance. What we did is that a major part of India's economic policy making, which is both legislative, policy implementation, which is executive, and decisions emanating from it, judicial, so executive, legislative, and judicial functions, at least a chunk of it, was literally outsourced out of the relevant government ministry into the hands of what is known as the independent financial regulators. We have too many of them now. We began with more simpler and unimaginative ones like the Telecom Regulatory Authority. Now we may have one on real estate too. But it is interesting to understand that many of the discussions that we have had, which sort of relates to how government functions or what economic governance is, needs to be reimagined in the way in which what is happening within these regulators, most of which do not perform what is known as regulatory impact assessments, most of which, unlike our parliament, is not accountable within the formal political accountability setup. So even if you oust the Narendra Modi government, you cannot oust the commissioners or the members of the Competition Commission of India, no matter however they are ruling, the way in which firms will behave. So that is that's how this I'm trying to imagine and contextualize this debate. A survey of the regulatory behavior of India's primary economic regulators, it reveals a pattern where learned lessons of India's socialist past is being innovatively brought into, almost manufactured into, the way in which the governance of modern economic firms are supposed to happen in this liberalized country. As a result of which, what is economic governance itself is a matter of confusion and debate. We have approximately 20, some of the sectors have approximately 20 years of this particular setup. To be honest, financial regulator, the prudential financial regulator, the Reserve Bank of India is older, but I'm talking about the ones that has come into being after 1990. So we have already have SEBI and the Telecom Regulatory Authorities, a good history of approximately 20 years to draw upon from. But I will focus today on the competition legislation as well as the Competition Act, and try to very briefly, because I do not have a lot of time, but this is a part of a larger project, to impress upon you that the fact that we are talking about that the license permit Raj has been replaced with that of markets is perhaps still a somewhat myth, because we have a modified license Raj permeating, which is known as the the regulatory Raj. where you do not, the principles of or the centrality of markets still is missing from the functioning of our economy. Now, I'll use a few cases to demonstrate to you why this happens and how is this being carried on. Now, this is, in my research shows, this is not a jurisprudential accident. It is not that suddenly these regulators behave in a particular manner. They're very conscious of what they're doing. Each of these regulators, and I repeat, each of these regulators have been birthed by a statute which has been, as we are very good in statute writing, a cut, copy, paste job of a Western mature economy. So when a particular regulation is being, a regulator is being formed principally through a statute, there are certain governing principles in terms of how that particular regulator will behave. If you look at the trajectory which many of them have taken, they have consciously deviated from that path of where centrality of markets becomes the governance doctrine or the mantra for regulating firms. And they have done it very innovatively. What I want to say is that they have attempted their best to interpret socialist concerns, consumerist concerns within the dogma of efficiency. I will give you, for today, I will only discuss the Competition Commission of India. Some of these cases I have myself been a part of, as well as member Gauri, so we are in some way at fault too. But there is, for example, as many of you know, a difference between what the competition legislation of a country does and what the consumer protection legislation of a country does. What the consumer protection laws does directly, in a way, competition law does it for the entire economy. So the idea is that the Consumer Protection Act will protect a single consumer who is consuming lead-infested Maggi, whereas the competition regulation will try to, through principles of efficiency, enhance consumer welfare, and in that process indirectly help each and every consumer. The Competition Commission, at least in few cases, and I will very quickly discuss them, have deliberately merged these two concepts. They have become, in some way, like the socialist state, very much like Indira Nehru Gandhi, the parents patria of that faceless consumer sitting somewhere in a small town. There is it's on record of a speech of the chairman of, the former chairman of COMPAT, which is the Competition Appellate Tribunal, a justice of the Supreme Court of India, Justice Sirpurkar, who says the purpose of competition law is to stand beside the Aam Aadmi, which essentially translates is to stand beside the common man. You could not have more regulated socialism than that. I am not for a minute saying that the task of competition law is not to enhance, not to work for consumers. But the way in which it is actually translated in reality creates a lot of problem for the state at which our economy is in. I'll give you, and there is a reason, there's a legacy behind all of this. One of my very good friends who teaches competition law at King's College, London, Dr. Angela Zhang, she wrote a paper called The Bureaucratic Politics of China's Anti-Monopoly Law, for which she won this year's Global Antitrust Award. And in my conversations, I realized that what necessarily needs to be done to understand what is happening in India, as much as in China, as Geeta ma'am was talking about, almost in all BRICS countries. In order to appreciate an enforcement regime outcome, one needs to question the realism and politics behind such enforcement choices. Without appreciating that, if we only look at what the Commission is deciding, without necessarily looking into the background or why such decisions are taking place, our inquiry will not be proper or adequate. I will take two examples. One of the most celebrated cases in the recent years of the Competition Commission of India has been in the sector of real estate. And unfortunately, DLF, which is one of the largest property, largest apartment builders or property real estate firms of India has been a target of much of that criticism. This is not for a minute for me to suggest that DLF is an angel. I'm not saying that. Perhaps many of what they do is problematic. But is it a problem for the Competition Commission of India to deal with it? Let me tell you what DLF essentially does. DLF has very onerous clauses in its apartment building agreements. For example, it will give you very low interest of return on the capital invested in buying an apartment if it defaults in giving you the completed apartment. But if you default on a particular payment cycle, it charges you a much higher rate. It tells you will have a plot of say 25 units. It gives you something which is 20 units. I am not for a minute saying that these are problematic. But is it a competition concern? Is it not a consumer concern? A concern for the consumer laws? Is it not a contractual dispute? The Supreme Court of India in 2007 has categorically stated and I quote, the power of the commission, in this case the Supreme Court was talking about the former MRTP commission, which is and the Competition Commission is the successor commission to this. The power of the commission to award compensation, therefore, is restricted to a case where loss or damage has been caused as a result of monopolistic or restrictive or unfair trade practice. It has got no jurisdiction where damage is claimed for mere breach of contract. In case after case, there's another case where the Competition Commission of India has penalized approximately 14 car companies for abusing their dominant position in the aftermarket of repairs and repair services and spare parts. It had taken inspiration from a very famous or rather infamous judgment of the American Supreme Court, the Kodak decision in terms of what aftermarkets constitute, knowing very well that that judgment itself is no longer followed in its principal country of origin. What the commission was concerned, and is primarily concerned, is what they define as consumer choice. The consumers should not be deprived of their legitimate range of choices. So, imagine a scenario where you walk into a KFC, and in the same podium, you should technically have available over there both KFC, McDonald's, Pizza Hut, everything. It's not a concern that KFC might wind up shop because their trade secret needs to be protected. They don't want it to be. They don't want the same platform in which all the other competing products are sold. I'm not getting technical as to how in terms of competition parlance there are vertical restraints and all of those things. But what I'm trying to emphasize to you is that the Competition Commission, one of the most enforcement hungry or one of the most powerful enforcers of this country, has given competition law an almost entirely different doctrinal approach than what the industry perceives it as. The industry wants it to create a more level playing field. The industry wants it to ensure that, for example, a small edge entrepreneur has access to the internet to sell its products as much as Facebook has. But on the other hand, the Competition Commission looks at these issues from the point of view of whether these will protect that faceless consumer standing somewhere in a Mufassil town in India. Now, this logic or this mindset of the Commission is something which I'm trying to demonstrate to and challenge through the research that we are doing at Jindal. Is unless you reinvent the wheel to the extent that you correct that the purpose of competition law is to make freer markets where obviously consumers are protected, but they're protected through the instrument of a competitive neutral market. You will not be able to make Indian entrepreneurship you will not be able to take Indian entrepreneurship to the heights you will want to. The situation becomes even more complex when we deal with the new cases in the high-tech center, every high-tech industry. All of you have heard about the investigation that is going on before the Competition Commission of India on Google. no matter how bad Google is, I can't live without Google. I do not know about you. So if the commission comes up with their consumer choice theory and the penalty that can be imposed upon Google given the amount that is permitted under the act is $5 billion US dollars, given its India revenue. So if Google winds up, so therefore the other quick area where the commission is now very much invested is in something called a standard essential patents. For example, as you know that our mobile phone is a conglomeration of a lot of smaller patents, and no matter what phone you're using, it's built by Macromax, but the patent to some extent is licensed to it by Ericsson or by Qualcomm or by somebody else who owns the technology. Now, the commission might very well be the only antitrust authority in the world which is on its way to set what a fair royalty rate is. These notions of trying to understand what is fair, what is a fair price, what contractual clauses are fair, is it a reasonable business practice? These are things which we believe, or our research wants to show, is a legacy of the way these institutions had behaved in the past. To give you an example, Section 2O of the MRTP Act defined restrictive trade practices as restrictive trade practices means a trade practice that has or may have the effect of preventing, distorting or restricting competition in any manner, and in particular, it gives two examples, which tends to obstruct the flow of capital or resources into the stream of production, which tends to bring about, and pay a little bit close attention to these terms, which tends to bring about manipulation of prices or conditions of delivery or affect the flow of supplies in the market relating to goods or services in such a manner as to impose on the consumers unjustified costs or restrictions. The ghost of this provision has not exited the body of the decisions which the Competition Commission has generated, some of them. Now, it is very important for you to understand that that there is no way that you can change the mindset of a new regulatory body if you are borrowing upon the lived experience of the older generation. You need to start afresh. You need to break apart in order to make India a truly market-oriented economy, which is the very purpose of a competition regulation. The same experiment can be done for several other regulators, and we hopefully will be, when we complete the project, we'll be able to produce a document which sort of reflects this sort of an exercise for all the 5 regulators. But in a nutshell, what I wanted to say is that the lived experiences of India's governance theories in some way is visiting upon the new model of regulatory governance that we are trying to build for our country. And unless we start for a clean slate, we'll actually be basically refilling an old bottle or a new bottle with the same wine. Thank you.